We'll call the next case, People versus Kevin Willis.
Good morning.
Good morning.
It's Ronald Ambrose. I'm appearing on behalf of Mr. Willis. And this is a situation where my client is certainly guilty of a couple of things with regard to this case. He's guilty of the possession of controlled substances, and he's also guilty of the offense of distributing obscene material to a minor. What he's not guilty of, Your Honor, is Section 750.145C2. And that section involves the material, child sexual abuse of material or activity. What I'm trying to suggest to the court is that it is the activity within the material that makes this a crime. The statute in itself is composed of three main areas. Subsection 2 involves the production portion of it. Subsection 3 involves the distribution of the material. And subsection 4 is just merely the possession of the material. So what I'm asking the court is to take this statute in context. Because if you do slice and dice this statute, yes, you can come up with a scenario that would make my client guilty of this section. But it takes much strain. It takes, like I said, parsing out certain words within the statute rather than looking at the whole context of the statute. When you look at the legislative history of this statute, what was the thing that was being prevented? Or it was child pornography. That was more or less the basis of why this provision was enacted. We already have statutes on the books that prevent what the complainant was alleging here, and that was engaging in the services of a minor for prostitution. The district court judge found that that was the correct bind over charges. The district court judge found that there was a requirement under the statute that there had to be some sort of making or producing child sexual abusive material. So that's why he did not bind over. Now, the circuit court judge had a different view of things, but he didn't have that view without some sort of struggling with it. If you look at the transcript of the motion hearing, he goes at some length in terms of trying to figure out what this actual statute means. And what he eventually comes up with is, takes a look at a non-standard jury instruction, and I think it was based upon a couple of cases, Aspie and Atkins, and comes up with that you don't have to produce the material, and that is the instruction that he actually read to the jury. I'm saying to the court that that was a wrong interpretation. Both Aspie and Atkins involved a 14-year-old person, or alleged person who was a purported 14-year-old. This situation, the complainant is 16 years old. We already have child sexual conduct or sexual conduct statute that prevents engaging in criminal sexual conduct with a person under 16. The interpretation by the court, both the Court of Appeals and the trial court, would render two people over the age of, what was over the age of consent, I think for most people in Michigan, was age 16. Now, the interpretation provided by the Court of Appeals and the trial court now makes that under 18, because even two consenting 16-year-old, 17-year-old people can be convicted under this statute.
Mr. Ambrose, I've read your brief, of course, and you make some very excellent points concerning things like harmonization and context and legislative history, and I take your arguments very seriously. I am concerned about the impact of the lower court's interpretation in this case upon our general structure of laws in this area. However, I've engaged in what you describe as the slicing and dicing process, which some of us might characterize as the interpretive process. And without too much strain, the slicing or dicing has produced language to me that reads, a person who attempts to arrange for any child's sexually abusive activity for personal purposes is guilty of a felony, period. I don't think I've added any words. I don't think I've taken away any words that are necessary to the process. And I guess I'm asking you, what is a judge to do with that language? I understand the contextual argument you make. I understand the impact that this will have on other legislative enactments. But I find it hard to harmonize language that's as explicit and as straightforward as that language without essentially amending or modifying what the legislature has clearly sought to accomplish here. What does a judge do with the language that I've just sliced and diced to that effect?
Well, I think if the court answers the first question that was posed is, whether or not there has to be some sort of material, I guess that is the answer I'm hoping that the court finds, that there has to be some material. What you just quoted, Your Honor, is almost exactly what I wrote down. I have ... a person who attempts ... to arrange for ... any child sexual abusive activity ... for personal ... purposes, if that person ... has reason to know ... that the child is a
And there's
child.
nothing to the contrary in those ... There's nothing that makes the product of that analysis misleading or disingenuous in any respect, I believe.
Well, it is what it is, but in the preface of your question, you do have to read the statute as a whole, and there, it's about dissemination, it's about producing, it's about making, and it's about possessing. It's not about the actual act of consenting people.
Counsel, we don't, in this circumstance, we don't have an issue of consent, right? I mean, we don't have those consenting 16, 17-year-olds, correct?
That's correct, but
So is consent, though, hypothetically, of a hypothetical 16 or 17-year-old victim, consent, and that be a defense available to a defendant charged under this statute?
no, I think if, as we read and sliced and diced this statute, whether or not they are two consenting 17-year-olds, they're both guilty of this offense.
Well, there is a statutory defense in the event that the victim is an emancipated, right? If they are able to prove by preponderance of the evidence that the under 18-year-old victim was emancipated, and the statute goes on to define it. But consent in and of itself of a 16 or 17-year-old who would be able to consent, right, under our other statutes, that is not a defense to this.
I don't see that as being a defense.
Okay.
You read it as a strict liability offense?
Yeah, a strict liability, yeah, offense, yes. I mean, it is, I can't, like Judge Markman, I sliced and diced it, and that's how I came up with the conclusion. Yeah, I have to concede that point. But I'm saying you have to read the whole statute in order to really understand what the ill that they were trying to prevent is the child pornography. Even if you go to the legislative history, that's what it says.
Is your more specific argument perhaps that we ought to be reading this statute in pari materia with other statutes.
I would suggest that, yes. I mean, and I cited in the brief, 750.520B, C, D, and E are the criminal sexual conduct statutes. If you also read the statutes before and after 750.145C, you got A, B, and C. All those statutes around that go into more or less child pornography type situations.
But you know, the harmonization process that we've described as being appropriate when you identify statutes as standing in pari materia with each other is not one in which we can simply ignore language or we can introduce contrary language into either statute, but it's a process in which we try to stretch a little bit to give reasonable meaning to the law in both instances. We try to stretch and exercise a little bit of flexibility in giving meaning to statute A and statute B. Here, I'm really interested in knowing what kind of harmonization process can we engage in giving meaning to the statute in controversy here that doesn't do damage to any kind of reasonable interpretation of 750.145C2.
Well, I attached, just the legislative history and, what it was that the statute was enacted for, and it specifically says it's child pornography. And I think a fair reading of the statute as a whole goes to that particular issue. This statute is, I did want to make a point prior to me having my time end, but this court has held in abeyance a case by the name of People versus Carl Perry, and it's docket number 158923. And in that situation, it does not involve a 16 or 17-year-old, but it's a plea-based conviction where the factual basis for the conviction was a criminal sexual conduct offense. Didn't have anything to do with material, didn't have anything to do with the making or producing, but it was a factual basis. My client, or Mr. Perry, was convicted, same judge and same county prosecutor. So I don't know if this is a situation where it's just the Wayne County Prosecutor's Office and this particular judge that's interpreting this statute this way, but I just wanted to make that point.
Counsel, I guess if we accept for present purposes that the statute prohibits a person from arranging or attempting to arrange for child sexually abusive activity, it seems to me that your client this case was presented to the jury as a case where your client was engaging in child sexually abusive activity with a person. And in fact, I think that's the specific instruction, or one of them, or something close to that the jury was given. But isn't arranging for activity different than engaging in the activity? All of the other terms in this statute that surround arranging are words that of sort of preparation, or somehow relate to the activity. They're not engaging in the activity itself. A person who arranges for, produces, makes, copies, reproduces, finances. None of those on that list are the activity itself. It seems to me your client here is charged with engaging in the activity itself.
Well, I do need to make this clear. He never
Or attempted to engage in the activity.
Yeah, and that's,
I get that. I'm just trying
that.
to parse the statute and make sense of it. And I'm going to ask your opposing counsel some similar questions. But in your view, was your client convicted of engaging in child sexually abusive activity? Or was he convicted of arranging for that activity to occur at some future point in time?
He was convicted of,
I'll help you out. The
Yeah.
instruction says engaging in that activity. And so I'm a little bit perplexed by the notion that, or by the fact that the word engage, or the verb engaging, doesn't appear in the statute. So that's,
The jury was instructed to find something that the statute doesn't
yes.
provide.
Yes, and that's what I and I quoted the what was read to the jury was all that he had to do was attempt to ask a 16 or 17-year-old, a 16-year-old in this case, ask him, would you like to engage in, a sexual act?
yeah, defendant attempted to have someone engage in sexually abusive activity with a person. I mean, it bears almost no relation to the statute. That's one of the four instructions that were given on this point. Is there a reason, I guess, to end this with a question mark, that you didn't make a bigger issue with the jury instructions?
I mentioned it in the second argument with regard to sufficiency of the evidence. And I quoted the whole, what was read to the jury. And what was read to the jury,
I know what you did, but you
Yeah.
could have raised it as a claim of error, right? That the instruction was not accurate.
yeah.
So,
Thank you, counsel.
All right.
Yep.
Appreciate it, thank you.
May it please the court, Deborah Blair on behalf of the people, the Wayne County Prosecutor's Office, the appellee in this matter. The court has asked the parties to address two issues in this case: whether to sustain a conviction for child sexual abusive activity, MCL 750-145C2, that the prosecution must prove that the defendant acted in order to produce material, and two, whether the evidence in this case was sufficient to sustain a conviction under that statute. I believe that the answer to question one necessarily determines the answer to question two. In regards to issue one, by its plain terms, MCL 750-145C2 does not require that the defendant produce any type of material to be guilty of violating the statute. There are multiple parts to the statute, and whereas one part is where a defendant would produce material, printed or otherwise, the second part is where a person reproduces or finances, and the third part of the statute, divided by the disjunctive term "or," plainly states that a defendant can be found guilty for attempting, preparing, conspiring, or arranging for child sexual abusive activity, which is defined as in the act as a child engaging in a listed sexual act. Notably, a separate definition is given for child sexual abusive material. Had the legislature intended only the making of child sexual abusive material to be a crime, they have had ample time to amend the statute to make this clear. In fact, the statute was last amended March 17th, 2019, with the operational language that we are discussing today left intact. And the amendment merely clarified that the mandatory minimum for a second offense on one of the subcategories is 5 years. Statutes are meant to be given their ordinary meaning, and courts are meant to give full effect to the language contained in the statute. If the statute allows for child sexual abusive activity as a crime and not just material, there was ample amounts of evidence in this case to show that the defendant was guilty beyond a reasonable doubt.
counsel,
Therefore,
was this a crime of opportunity, or did it involve planning and preparation?
I think it was both. I mean,
What was the planning and preparation part?
well, they met by happenstance, but the planning and opportunity would be inviting him up to his apartment and then locking the door and then inviting him into the couch. And the defendant had on his cell phone already the video of two men engaged in sexual intercourse, which he showed to the victim. So that I interpret, there must have been some pre-planning. He loaded that onto his cell phone, so.
Was the defendant planning, you think, to do something in the future, or was he doing whatever he was up to at that moment?
Oh, I think he was going to do that if the victim had not escaped out of the building. The evidence indicates that he...
No, I understand. The point is, was he preparing to do something in the future, meaning not a minute later, but an hour or 2 hours or 2 days later?
No, it was going to be that evening.
Right at that time, it would appear, right?
I believe so, because the victim got up from the couch at one point, and the defendant put his hand on his shoulder and put him back down on the couch, then put his arm around him, and then took out his smartphone and showed him the video of the two men engaged in sexual intercourse and said, "This is what I like to do." And at that point, he offered him 2 different sets of money to engage in sexual activity. Therefore, we believe that the acts of the defendant meet the criteria of the statute, and that we ask that leave to appeal be denied.
Counsel, if I'm trying to figure out how somebody knows that they're exposed to criminal liability under this framing of the statute. So assume 2 17-year-olds are very much in love and going to the prom, and they go online to research what exactly they can accomplish that night after the prom, because they want to do something a little more than make out. And they find out they're 17, they actually can do whatever it is they want to do, and the CSC statutes don't apply to them. And then an aggressive prosecutor charges them both under this statute because they've each violated it under this construction. Do we just have to rely on no prosecutor would really charge that, and if they did, they'd get voted out of office? Is this one of those cases where, to give full effect to the legislature's language, we have to allow for some, silly potential prosecutions and rely on decent prosecutors not to charge the prom kids?
I think under some extreme examples, you could theorize that 2 consensual 17-year-olds could be found guilty under the statute, but as you say, it's never happened. It's never been prosecuted that way. And also...
Well, I don't know if it's never happened. I was just assuming most prosecutors wouldn't charge it, but you agree with me that they'd both be subject to liability. They're both the individual and the victim in this case, if we uphold this construction, yes?
Theoretically, although the statute itself talks about abusive activity, But
abusive is defined within the statute itself, and it tells us everything that's covered, and it seems to me erotic fondling might be the kind of thing that prom kids engage in, and if they did engage in erotic fondling, they'd be liable under the statute per this construction, right?
Correct. But there's multiple instances where, in some instances, the age of the statute is 16 and under, and in others, it's 18, and there's no, discernible reason why the legislature has separated the two. For example, MCL 75449A, engaging or offering to engage the services for prostitution, is the age is 18, it's a 5-year max, but 75014A, accosting, enticing, or soliciting a child for immoral purposes, you have to be 16 or under, and it's a 4-year max. So there are internal differentiations in the legislation between 16 and 18, but that doesn't mean that we have to throw out this statute entirely, because the language says what it says, and it clearly applied to this defendant.
Counsel, can you address the issue raised by Justice Viviano about the instruction given in this case, which was not the model instruction, and the language of the statute? I think in light of how the Court of Appeals has interpreted it, that the word engage is used in that first clause or first category of defendant that is specifically limited for the purposes of producing the material, correct?
Correct, absolutely.
And it's this second category that doesn't have that same limitation, that, for the purposes of producing the material. But And the Court of Appeals says clearly that first category doesn't apply to this defendant, right? So
Right.
we're in that second category, which does not employ the word engage. And yet the definition given in the instruction to the jury in this case did include, you know, attempting, preparing, or attempting to make or arrange to have someone engage. So can you address whether or not how that instruction could still be proper under the statutory language?
Yes, because part of the sexual abusive activity statute talks about passive sexual involvement. And in this case, we have the defendant showing the pornographic video to the child. And under the statute, that is considered passive sexual involvement because and that would mean, that would apply. So that's where I think that language is applicable.
Can you connect the dots a little better for me?
Passive sexual involvement means an
I see
act
it's a
real.
defined term in the statute, but is it mentioned in the section that we're looking at, subsection 2?
No, it's part of the definition of, it lists all the different sexual activity, and that's one of the types. Is
Oh, I
passive
see.
sexual involvement means an act
I
really
see.
stimulated that
But counsel,
exposes
you
another
mentioned-
person.
You mentioned the video
Yes,
as if that's somehow relevant here. There's 101 other ways that this law could have been violated without the video. This is not really, in your view, essentially a media statute in any way, is it?
no,
Okay,
no. The other way it could have been violated was the defendant offered two different sets of money for two different sets of sexual activity. So I believe there was two separate categories: the showing of the video, which is passive sexual involvement, and the offering of $25 and $100 to engage in sexual activity.
Isn't this kind of an indirect and cryptic way of undermining, diluting, nullifying one of the principal criminal law statutes of our state, that pertaining to CSC crimes? It's pretty hard to identify exactly the circumstances, the whereabouts, the applicability and breadth of this statute, isn't it? And in light of some of the indirect and kind of obscure analysis that we have to engage in order to uncover it?
Yes, but I think the legislature and the laws in its entirety is moving away from this idea of 16. If you look at the human trafficking law, all talks about 18. I mean, and now the marriage statute talks about 18. So the legislature, and I think the current thought process is to move away from this idea that 16-year-olds are capable of being held to the standard and moving towards the 18. Even for, criminal liability purposes, the legislature is talking about moving the date up to 18 instead of 17. So I just think it's part of what the legislature is trying to do.
Thank you, counsel.
Thank you.
The case will be submitted. Thank you.